seated. Welcome, folks. We are here for oral argument in our case number CV25-0183, Pelchat versus Banner Health et al. Just a reminder to everyone in the courtroom to silence your phones so we can avoid some disruption and embarrassment. As I imagine you're familiar, we do record and live stream these proceedings, so please introduce yourself and your client when you begin. You will each have a maximum of 20 minutes per side. You are not required to use all of that time, but you are welcome to it. To the extent appellant would like to reserve time for rebuttal, that will be up to you to manage with the clocks on the podium. And I understand that appellees are not intending to split time? That's correct. Great. Well, please keep in mind we have reviewed your briefs, we are familiar with the record from below, and we have already conferenced the case today. So we're familiar. So please proceed and jump right in.
Good morning, Your Honors, and may it please the Court. The trial court's dismissal of this wrongful death action was, my name is Nikisa Azizi, and I'm the attorney for Ms. Pelchat, the plaintiff appellant in this matter. The trial court's dismissal of this wrongful death action was based on a fundamental error. Simply put, it conflated the egregious factual backdrop of this case with the distinct accrual dates of plaintiff's alternatively pled claims. By focusing on defendants' shocking conduct, like their forceful admission of an elderly woman to the Banner Boswell Medical Center and subsequent administration of an unauthorized, federally incentivized drug, the court wrongly concluded plaintiff's entire case, including her ordinary negligence claim, was necessarily actionable prior to this court's invalidation of ARS Section 12-516. This was a gross misapplication of Rule 8, which requires analyzing each legal theory independently. That failure is reversible error. With this procedural flaw clarified, the First amended complaint presents three independent pathways to timeliness. First, plaintiffs claim that defendants negligently mismanaged decedent's heart condition could not have accrued until September 19, 2023, the date this court partially overturned Section 12-516 in Roebuck v. Mayo Clinic. As our state Supreme Court recently affirmed, Section 12-516 unconstitutionally abolished the common law right of action for ordinary negligence in connection with declared public health emergencies, in violation of the Arizona Constitution's anti-abrogation clause.
But the statute didn't prevent Ms. Pelchat from filing suit, right? It just required her to prove more in order to prevail. It required her to prove gross negligence in order to recover damages. So she could have filed suit earlier while the statute was in effect before Roebuck declared it unconstitutional, but would have been required to prove more at trial. Isn't that right?
Thank you, Your Honor. My understanding is that this court in Roebuck v. Mayo Clinic determined that gross negligence is not a reasonable alternative to an ordinary negligence claim. So they determined that the bar on ordinary negligence, which, in other words, requiring gross negligence or willful misconduct in order to pursue a malpractice action related to COVID-19, was not a reasonable alternative that would constitute mere regulation of a common law right of action. It was a complete abolition, and therefore that part of Section 12-516, specifically Section 12-516A, was unconstitutional under our state constitution for that reason. And also, according to the First Amendment complaint, which must be taken as true in ruling on a 12b6 motion, the claimant didn't know that defendants had negligently mismanaged her mother's heart condition until she spoke with an expert after Roebuck invalidated 12-516, because that was when
ask a clarification on 12-516. It is a statute that provided immunity, but as I understand it, the immunity it provided was not immunity from suit altogether. It was just a liability immunity. That's what the heading suggests. So if it's an immunity from liability, that means that a plaintiff could bring a suit even for simple negligence, not just gross negligence, or either of those claims, could have brought the suit even while the statute was still fully in effect. It's just that there might not have been liability. The defendants would have immunity from liability if they were able to establish good faith.
Well, Your Honor, my understanding is that the claim altogether was abolished, and so there was literally no way. The Supreme Court determined recently in September that it was a legal impossibility to prevail on an ordinary negligence claim under 12-516, and that's the claim that's on appeal. So there would be.
But it bars an ordinary negligence claim in the absence of good faith. I mean, that's the language that's right there in the statute.
Right.
No, good faith or bad faith is not normally the sort of thing you'd have to prove in a negligence claim. So it doesn't abolish all simple negligence claims. It abolished, or not necessarily abolished, or prevented liability for simple negligence claims where there was an absence of good faith. So it didn't do away with simple negligence altogether, did it?
Well, my understanding was that this court and the Supreme Court of the state determined that it completely abolished the private right of action for negligence in the medical malpractice arena involving declared public health emergencies. But also, that brings us back to the conflation of the factual background with the actual legal claims in the First Amendment complaint. So if you look at the factual backdrop of the case, yes, like I mentioned in the opening, there's an allegation that there was this protocol essentially of admitting patients, for example, in this case, an elderly woman who just had an orthopedic complaint, didn't have any respiratory complaints. And the moment her family stepped out, the complaint alleges that she was admitted with supposed extreme deterioration in her condition just after her family stepped out. And therefore, they needed to admit her for COVID-19 and treat her for COVID-19 with remdesivir, which was a federally incentivized drug.
And Mrs. Easy, on the point of remdesivir, you were not appealing the trial court's dismissal of your claims related to the administration of remdesivir under the PrEP Act, correct?
Correct, Your Honor.
Okay. And I also just want to clarify, you are not appealing the trial court's dismissal of your survival actions based on the fact that your client was not appointed as personal representative. Am I correct about that?
That's correct, Your Honor.
Okay, thank you.
Yes. So going back to the bad faith aspect of it, yes, there are some factual allegations relevant to some of the intentional torts in the complaint that deal with bad faith and the scheme essentially to profit from the pandemic that were at play. But by the same token, under Rule 8E, you can plead claims hypothetically and alternatively, and if any one of them is sufficient, the whole complaint is sufficient. So what our stance is that the lower court conflated this backdrop of basically institutionalized malpractice with the allegation that negligently, intentionally, or recklessly they mismanaged her heart condition, which was not related to remdesivir. It wasn't related to the CARES Act or the PrEP Act.
But the trial court dismissed your First Amendment complaint based on the statute of limitations, not on the PrEP Act, correct?
That's correct, Your Honor.
Okay.
Essentially, if you look at her ruling.
Let me just follow up on a point that you were just raising. The complaint includes allegations about falsification of medical records, that they included false information about shortness of breath, and you refer to record-keeping shenanigans and that sort of thing. Do the allegations in the complaint about misrepresentations in the medical record, does that affect the accrual of the cause of action? And what allegations in the complaint would indicate that the misrepresentations delayed the accrual of the cause of action?
Well, Your Honor, there are allegations of fraudulent concealment. So, as we know, fraudulent concealment can either delay accrual or it can toll the statute of limitations even after a claim is accrued, and that's under Morrison v. Acton. And here we have a situation where the plaintiff, her mother was admitted under the pretense that this was for COVID-19. She was told that the decedent, her heart rate had dropped, but they fixed it after they meddled with the machines, and that she died of COVID-19, and that complications related to COVID-19 were responsible for her death. So then when she finally got the records, she saw in there exactly what the narrative was verbally, that this was all COVID-19 related. However, as a layperson, just as in Morrison v. Acton, she wasn't capable of deciphering from those records that they had negligently mismanaged her mother's heart condition. And if you look at Morrison v. Acton and Walk v. Ring, there's a higher bar when it comes to ending tolling related to this fraudulent concealment, because it's not enough that you're on notice of potential negligence, which was the case in Walk v. Ring. Here, we're in a situation where you also have to discover the facts that were concealed themselves, or reasonably be on notice of those facts.
Okay, well, when she received the medical records, did that give her the information she needed to know about the cause of action, or are there allegations in the complaint that the records were doctored in such a way that delayed her understanding of what really happened?
Well, Your Honor, I believe based on her status as a lay person, just like, again, going back to Morrison v. Acton, who couldn't read the x-rays and determine that there was a piece of something left in his mouth from the prior surgery, my client, she couldn't recognize, she just noticed remdesivir, she knew that word, but she's obviously not a doctor, so she didn't know, she's not a cardiologist, she didn't know that they had overdosed her mom on digoxin and other heart medications.
Okay, but is that because she was a lay person and couldn't interpret the records, or because the records themselves were false?
So that's because she was a lay person. But there is an allegation in there that the records were revised. One of the records in there has been revised, and we don't know how it was revised. But just the fact that she's a lay person, to me, is sufficient to demonstrate that it's not enough to receive medical records to automatically be on notice the day you receive the medical records that there was malpractice unrelated to remdesivir or the scheme to profit from COVID-19. And therefore, the statute of limitations would have been told until she was reasonably put on notice of the concealment. So the concealment involved all kinds of things. It did involve remdesivir, theoretically, because they gave it to her, even though in the complaint, there's the allegation that she specifically told Stapleton, Dr. Stapleton, that she doesn't want remdesivir for her mom. So that was immediately what she noticed, and that's why she went to seek counsel.
But I didn't see any allegations in the complaint that there was information that was concealed in the records that later came to light. Are there any such allegations?
Not to my knowledge, no.
Mrs. Easy, if I could ask you a different question. Let's say, for the sake of argument, that we conclude that there's no equitable tolling available here, and what we have here is your client's claim accrued when she received the records. Can we read mid-January 2022 to include January 23rd, such that your lawsuit would have been filed within 2 years of the accrual?
Your Honor, thank you for the question. The way I read the First Amendment complaint is that it took my client a number of days. That's the key phrase that's been, contested, I guess you could say, on appeal. It took her a number of days, sometime after mid-January 2022, and we don't know when mid-January 22 is. It's the middle third of January, I guess you could say. So clearly, reading the First Amendment complaint, taking all the facts as true, and reading them in a light most favorable to the plaintiff and indulging all reasonable inferences therefrom, a number of days, sometime after mid-January 2022, could clearly make this January 23rd, 2022, or later, when she discovered the remdesivir.
But if we conclude that the date of accrual is the date the records arrived, can we read January 23rd to be part of mid-January?
I would probably concede that the 23rd would not be mid-January, if that's the question.
That is
Your
the
Honor.
question.
Okay. Yes. So
just to put a finer point on that, are you saying that as a matter of law, January 23rd cannot be contained within mid-January?
No, Your Honor, I'm not saying that. I'm saying that I think theoretically, reasonable minds could differ on whether January 23rd is within mid-January. However, I don't really think it's necessary for us to speculate about that because under a Rule B12-6 motion or on a Rule 12b6 motion, the only way to dismiss a cause of action under Rule 8 for failure to state a claim on a statute of limitations ground is if it's facially time barred, and we simply don't have that here because by definition, if it's not clear when in mid-January or how long it took her to look those records over, we don't know when the 2-year accrual date began, the 2-year statute of limitations began, and therefore it cannot simply be said as a matter of law that it's untimely on its face by definition.
Thank you.
And I'll go ahead and continue then, if that's all right. And I did want to save the last few minutes for a rebuttal, Your Honors. Okay. So we talked about fraudulent concealment. Also, I mean, we touched on all of these issues, but I'll just quickly go through this just in case I missed anything. All right. So plaintiffs claim that defendants negligently mismanaged the decedent's heart condition could not have accrued until September 19th, 2023. We touched on that. Okay, defendant's position that the statute of limitations ran while the claim was legally non-existent turns the discovery rule on its head, meaning the idea that this could have accrued before Roebuck. It goes without saying that one cannot discover a claim that does not exist. The claim didn't exist because it's an ordinary negligence claim, not a gross negligence claim, not a willful misconduct claim. So, accordingly, I'm sorry, I lost my place. It goes without saying that one cannot discover a claim that does not exist. Moreover, the 4-month window following Roebuck is not a reasonable alternative to the ordinarily applicable 24-month statute of limitations. And the reason I mention that is because in defendant's response, they suggest, well, let's say the statute started ticking the moment that she got the records in mid-January, whenever that is, then that clearly was sometime before January 23rd, 2024 that she had to file this. And Roebuck was in September of 2023, so she had 4 months. But again, under the anti-abrogation clause, there has to be a reasonable amount of time to discover your cause of action and file it. So here we're talking about a 24...
So what prevented her from discovering her cause of action? What about Roebuck prevented her from discovering her cause of action?
Well, as...
Or more accurately, what about 12.516 prevented her from discovering her cause of action?
So, as mentioned in the briefs and in the record below, attorneys are permitted to presume the constitutionality of a statute. So when my client was going to attorneys, the moment she noticed remdesivir and she started contacting attorneys about, is there anything she can do about this? Because, they were looking at the PrEP Act and saying, well, remdesivir is a covered countermeasure, so no, you can't really sue for that unless you can show willful misconduct, and you have to do that in Washington, D.C. Under ARS 12-516, anything COVID related that wasn't gross negligence or willful misconduct was a non-starter. And she didn't have any, as a layperson, she didn't have any knowledge that they negligently mismanaged her argument. All she saw is remdesivir, and she's going to all these attorneys. They're turning her away, saying these people are immune. You don't have a case. Remdesivir is a covered countermeasure, so under the federal law, they're immune. Nobody was willing to take her case because of Roebuck. Once that bar was removed, and she was able to actually find an attorney, then she could, and I personally was able to get a medical expert to actually look at her case. So, in Kenyon v. Hammer, there's a concurrence by Justice Hayes, and he says, a statute of limitations that abrogates an action for damages before it can reasonably be discovered is unconstitutional. And so that's the situation here. Even if she were on notice of a negligent wrongful death claim when she saw the remdesivir, even though the negligence is completely unrelated to the remdesivir, even if that could be said, the fact is that she couldn't have discovered the actual negligence at issue until she could, one, convince an attorney to take her case, and two, have time to actually have a medical expert look at her case. And no one's going to look at your case if there's an immunity statute in place that says you have to show willful misconduct or gross negligence, and she literally has nothing other than a covered countermeasure that is already barred by federal law in terms of, getting any kind of recovery. So, and I don't have any more time, but I'll just save the last minute, I guess, for rebuttal. Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. My name is Kelly Jankaitis with Broning, Oberg, Woodson, Wilson. We represent Matthew Stapleton. Also here at council table is Elizabeth Peterson from Slattery Peterson, who represents Banner Health and the other defendants. We did file a joint brief, so I'll be presenting argument for both of us unless you have any questions specific to the Banner defendants, and Elizabeth is available for that. I'll refer to the defendants collectively as Banner probably during this argument because our positions are aligned. Here, the record and the undisputed allegations of the complaint show that there was no barrier to plaintiffs filing a timely complaint, testing the legality of 12-516, obtaining a medical expert, and litigating the merits of the case. There's no facts in there that suggest she couldn't have filed on her own, that she tried to file on her own but was unable to do so. And there's no law that supports equitable tolling based on the fact that someone hasn't been able to identify an attorney to assist them.
It seems to me that the trial judge determined as a matter of law that mid-January of 2022 fell outside the 2-year statute of limitations. How can a judge determine as a matter of law what mid-January means?
Well, Your Honor, the court, well, it's a question of law. Sorry, let me start over. When a cause of action accrues is a question of law when the facts are undisputed. And in this case, plaintiff suggested that she wasn't able to determine when her cause of action accrued until she received these medical records in mid-January of 2022. But the facts asserted in the complaint don't state a claim for a January 23, 2022 accrual date because plaintiff has the burden of proving their statute of limitations defense, which is the discovery rule. And in order to assume her facts are true, they have to be capable of proof. And plaintiff has already admitted in the record that she doesn't know when that occurred. So the way that the complaint is written.
But isn't the plaintiff's I don't know when that occurred, isn't that tied to the review of the record? It's not explicitly tied to the receipt of the record. I mean, we do have, at a minimum, we do have a allegation of receiving the records in this mid-January time frame, and it's the court's duty to construe that, any inferences from that in plaintiff's favor.
I see. I was mistaking your question for the reading of the records as opposed to the receipt of the records. So plaintiffs conceded today that they're not arguing that January 23, 2022 occurred in mid-January, and that wasn't an argument that was raised below. So that argument has been waived. I would also contend a reasonable reading of the word mid-January 2022 is January 15th. And if you add 7 or 8 days in either direction.
If you could allow.
It's a reasonable reading. Is it the only reasonable reading? Or is it the only reading that we can arrive at that January 23rd necessarily, as a matter of law, falls outside of mid-January?
I think yes. I think if you're subtracting 8 days from January 15th, that's January 7th, and that is not mid-January. I don't think any reasonable person could say that January 7th is mid-January. That's early January, January 23rd, 8 days later, late January. But the court doesn't need to get there because, again, accrual is a question of law when the facts are undisputed, and the facts in this case show that the causes of action actually accrued in October of 2021. According to plaintiff's own facts in their complaint, in October 2021, the plaintiff knew that the decedent had not had any respiratory symptoms, that the Banner nurses were messing with her oxygen, and that Banner wouldn't provide the requested treatment that she had made for the COVID-19.
But aren't her claims now related to the heart medication, matters that are kind of divorced from some of the allegations that were made about some of the things that happened in the hospital? I mean, would she be necessarily on notice to investigate this allegation regarding the heart medication based on the allegations that you're talking about that occurred right at the admission to the hospital?
And Arizona law doesn't splice it that finely.
Can you give me a case that says that?
I can't off the top of my head,
Okay.
but the cause of action accrues when you have a duty to investigate whether you have a cause of action and when you know the who and the what. The who, right, the who and the what.
Another way we have articulated accrual is to say that a cause of action accrues when one party can sue another. Would this plaintiff have been able to bring a simple negligence action against your clients before this court invalidated 12.516 in Roebuck?
Sure. Nothing about the passage of 12.516 prevented the plaintiff from filing a lawsuit, challenging the constitutionality of the statute, or trying to bring her claim within those bounds. And a lot of her claims don't relate to COVID-19.
If I could please.
Sure.
To put a finer point on Judge Beck's question, is the only claim she could have brought a challenge to the constitutionality of the statute, or was it possible for her to bring a simple negligence claim while the statute was still fully operational?
It was also possible for her to bring a negligence claim and try to fit her claims within the bounds of the statute. Because if you look at her allegations, she is not alleging any good faith actions or medical care was provided by Banner. She alleges that Banner kidnapped her mother and forced drugs on her as part of some scheme to make money at the expense of patients. I think she even accuses Banner of murdering her mother. There's no good faith alleged in this complaint.
And I think we would concede that there are intentional torts that are argued. There is gross negligence that is argued. But are you saying that we must necessarily say that the simple negligence claims, that all of those allegations are applicable to the simple negligence claims? You know, if she had only a claim for simple negligence, for instance, could she have brought that claim when 12.516 was in effect?
Yes, she could have filed the lawsuit. There's nothing that prevented her from filing a lawsuit. If the defendants want to claim immunity, that's an affirmative defense that they plead back to that.
So are you or are you not saying that the statute barred a simple negligence claim? Like, is your point that she could have brought, I mean, anybody can bring a frivolous claim that they are not entitled to bring. I think we're trying to get at something a little bit more specific than that. Was a simple negligence claim barred by the statute at the time?
Arguably, it was barred, but that's something that you have to file and litigate.
Okay.
So I don't think it would have been a frivolous claim to file.
Okay.
It's worth noting, too, that that statute was declared unconstitutional before the statute of limitations ran, and that did not prompt this plaintiff to file a lawsuit within the statute of limitations anyway. Again, I think that October 21 date is really persuasive if you look at the actual allegations in the complaint. The plaintiff relays that she was scared that her mom wasn't getting enough nutrition, that she was shocked by the hospital admission. She had no reason to believe her mom had any of those symptoms when she was living with her before. She feared her mother had been kidnapped. She described all of that conduct as egregious. And then her mother died a few days later. She certainly was on notice to investigate the cause of that death and whether or not it was a wrongful death that could give rise to a wrongful death claim, like the ones that she brings.
But I think that line of logic really does not account for Walk v. Ring and Morrison v. Acton, both of which said these plaintiffs were fully aware of the injury itself for an extended period of time before the court determined accrual started. So could you walk me through how you distinguish those?
Sure. This wasn't just the fact of a death. This was a death that followed plaintiff admittedly observing what she thought was substandard medical care and being actively concerned that Banner was doing something that they shouldn't have been doing. Those are the facts that are alleged in the complaint. So it's different than a situation where you just know that someone died, but you don't know the who or the what or what may possibly have led to that or suspect that something might have gone.
But it isn't, I'm trying to remember which one's the dentist case. I think it's Morrison.
I think that's right.
Okay. The leaving the drill bit in the plaintiff there knew that this was an injury, knew the who, and knew that it was an injury after a specific procedure, just didn't know that there was that type of negligence.
Yeah.
I guess maybe if you could help me with that.
Sure. In that case, the plaintiff went to the dentist, and the dentist was like, yes, you have this in here, but I didn't do anything wrong. It wasn't me. It wasn't negligence. And that fact is missing here. Mm-hmm. So that was like the defendant had actively concealed what had led to the negligence, prevented them from discovering that it resulted from negligence as opposed to.
But hasn't plaintiff then pled facts that we are to entertain as well-pled facts, that there was concealment here, at least in particular as to the heart issues that Judge Brett raised earlier?
What plaintiff has alleged is the words fraudulent concealment, but there are no facts that support fraudulent concealment. Her complaint is that Banner did not give her a call and say, hey, we were negligent, and that's not required, and that's not fraudulent concealment.
I mean, trying to be a little bit more fair to the plaintiff as we are entitled or required to do here. I think that's perhaps a bit of a hyperbolic characterization of her concealment claim. She does claim that there was at least some records that were altered, but she's unable to discover how. Isn't that specifically a concealment claim in this equitable tolling space?
Even if that's true, that's such a small part of the overall picture here about what the plaintiff knew and should have known and was on duty to investigate in this case. And she doesn't allege that kept her from discovering her cause of action eventually in January 2024. She hasn't connected any issues with the records to an actual inability to discover.
As you correctly point out, the complaint includes allegations about that the plaintiff was aware of bad things happening in October of 2021, things that they shouldn't have done, and they were rude, and they were dismissive, and they kidnapped, and they did all these things. But that doesn't mean she was on notice that they were mismanaging a heart condition, right? I mean, doesn't it have to be something more specific to give rise to a cause of action based on alleged mismanagement of a heart condition?
I am not aware that this is an argument that the plaintiff has made, but the plaintiff was on notice for sure to investigate the cause of her mother's death. And she had the medical records that were necessary to determine whether or not mismanagement had occurred, and she had them for over 2 years before she filed suit. So even if that were the case, and you look at a January 2022 accrual date as opposed to an October 2021 accrual date for that specific claim, the complaint is still not timely.
Well, the opening brief does talk about the allegations in the amended complaint about the negligent mismanagement of decedent's heart condition and its causal connection to her death. So it's not like this is a new point being raised for the first time today.
No, it's not new to the complaint, but my recollection from the briefing is that the plaintiff hasn't separated out the causes of action in that manner. I mean, her position is that the accrual date's in January of 2024. And that is not true. That is when her expert told her that she had expert support for a claim that she had already been investigating for over 2 years. Unless the court has any other questions, we'll stand on our brief. Thank you.
Thank you.
Okay, Your Honors, did you have any other questions for me based on that response? Okay, well, I did want to just touch on a few things that were discussed just now. let me find my notes. So the defense just argued that Walk v. Ring is different from this case because in Walk v. Ring, the dentist told the patient that he wasn't negligent. However, in this case, there's an allegation in the First Amendment complaint, paragraph 135, that defendants deliberately misled plaintiff into believing that her mother had passed away from COVID-19. This was done verbally when my client was discussing the incident with the heart rate going to zero, essentially, and being told that, basically being mocked about her views on COVID-19 and clearly insinuating that this incident was just due to COVID-19. And later, of course, as mentioned, the death certificate itself represents in writing in an official document that the death was due to COVID-19. And these were misrepresentations, but the defendants haven't contested, not once. Oh, sorry.
Thank you, counsel.
Oh,
Your
already
time
won.
has run.
I'm sorry.
That's fine. We appreciate your arguments. We appreciate all your time today and the helpful briefing. We will take the matter under advisement
thank
and
you.
issue our decision in due course. That court is adjourned.